Real people, real cases. This is Verdict Watch.
Court calls the case of Mrs. Haberkamp versus DeAndre Searcy.
David Fainter on behalf of plaintiff.
The case begins, Mrs. Haberkamp versus DeAndre Searcy. Right away, the tone is set. This isn't just about unpaid rent. It's about frustration, broken trust, and survival. The attorney outlines a deal. $4,398 owed with a plan for $750 monthly payments starting in June. That's nearly double the tenant's actual rent. What do you think? Is this a fair compromise, or does this push the tenant too far?
We were just finishing this one up.
Okay.
So here's where I think we're at. I think we've got an agreement. The amount of rent that's owed is $4,223. There's $175 in court costs for a total of $4,398. He's got $270.
DeAndre explains he'll pay, but his frustration spills out. He complains about unsafe living conditions, neglected repairs, and even people loitering in hallways. His message is clear. Why should I pay full rent when my landlord isn't holding up their end? Should tenants still have to pay in full if landlords fail to provide safe, livable housing?
Right now, but it's on his card, so he's going to turn that into a money order and drop it off. And this is the address you're going to drop it off. 206 North Huron. Take this. And then what he's going to do starting in June, he's going to start paying on the 5th of the month, $750 per month. His rent is basically $275. So by paying the $750, the first $275 will go to the rent, and anything over and above will go toward the arrearage. It'll take a while, but we'll work with him. He's lived there for a while. He's on Section 8. And this was the deal that we talked about last time.
Right.
And
the pressure builds. DeAndre admits $750 a month is his whole check. His only income is Social Security, not nearly enough to cover living costs and rent. Yet he says, I ain't got no choice. The courtroom tension is heartbreaking. Compliance out of desperation, not agreement. Do you think this shows the imbalance of power between landlords and tenants?
so I just need him to sign this conditional dismissal. And right there. And then the court will inform you of your rights.
Do you have any questions regarding anything on that conditional order dismissal, sir?
Yeah.
The landlord's attorney pushes back. He's only made 3 payments in 18 months. DeAndre fires back, saying management changes left him confused about where to pay. The clash reveals a bigger issue. Tenants get punished when landlords and management companies fail to communicate. Who's really at fault here? The tenant for falling behind, or the landlords for poor management?
He didn't tell me how long my lease up, because man, I'm getting tired of what I'm staying with. They don't fix nothing, and still got people laying in the hallways and everything. It's just a whole bunch of harassment. They hassle me over this money where it's been over like 3 or 4 landlords, and they don't get in touch with nobody. But right now, Section 8 on them because they not fixing my place, and Section 8 involved and they trying to kick me out. And I'm like, they didn't even fix it what they got to fix for me to order to even pass my my eviction to check the house out.
Okay, so do you want to
I don't think
do you want to enter into this or no?
I do, but $750, that's a lot. That's all my whole Social Security.
This is the same thing he did last time.
I mean, I'm okay with it, but I'm just putting suggestions out there. Because, I only get my Social Security is only like
the judge makes it plain.
Then I get 100.
If DeAndre refuses the deal, this case will go to trial, and he'll almost certainly lose more. Trapped between 2 bad choices, pay money he doesn't have or risk eviction, he reluctantly agrees. His voice cracks with frustration, but he signs anyway. This moment shows the painful truth. Sometimes court agreements aren't choices at all, just survival strategies.
$12. Then I got my tickets I paid off. I gotta find where to do the yard work for that. Washington don't do that no more. You know, I got a whole all this stuff on. That's just like it's okay. I can pay it, but I think that's too much. Even where I had to find a landlord, and I got people on my.
If you're
Next case, Sycamore Meadows versus Erica Jefferson. She's accused of owing nearly $3,900, but she pushes back hard. That's not true. My rent has been $0 since last year. Her outrage is raw. She claims the numbers are simply made up. The judge, even confused, questions how the math adds up. How often do you think tenants are hit with inflated charges they don't actually owe?
outside.
but it sounds to me like you're not agreeing to this.
I'm
So-
agreeing to it.
Your Honor,
I got to. I ain't got no choice. I can't be kicked out. But I just think, you know what I'm saying, everything ain't my fault.
Your Honor, may I?
Yes.
Last time we were here, he complained about money that he thought he owed when Beal managed.
When I'm telling you now.
So I took that off.
Mm-hmm.
We got management back, MTH did, in December of 2023. Since that time, there's 18 months. He's made exactly 3 payments.
Because I didn't know who to pay it to. They
Well,
didn't tell us who when they switched
I-
landlord. They didn't tell the whole business. Oh, we doing switching landlord like a business supposed to do. Here's the note on the door for everybody.
So if you want me to enter this, then I will. If not, and you're not in agreement, then I won't enter it. And I'll set it for trial.
The judge calls for a delay, saying the math doesn't make sense. Erica is sternly warned not to yell again in court, but her anger shows how powerless tenants often feel when the system seems stacked against them. Transition from unpaid rent to improper eviction notices, the next case highlights how even landlords can trip up legally.
But if we have a trial, it'll be a number and he'll have to pay it, because this is what happened last time, which is we came to an agreement and then we got to the podium and
I would say I'll do agree. I'm just saying, like, I just want to put my point across. You know, I got the right to speak, but I just think, I'm gonna pay it. But
Okay, so you want me to enter this conditional order of dismissal?
Yeah.
Mr. Sisson?
you ain't gonna bring it down no
Do you
more.
have any questions regarding anything that's on?
No, that's it.
All right. Gonna sign off on this.
Just make sure you
You have
can't.
3 business days to think about this. If you believe that there's some legal reason, some right you didn't assert, or some confusion on your part, you'd have to file a motion with the court within that time frame. That doesn't mean that I would set it aside, but you have that time to do so.
Case 3. Corwin Shakes versus Bernadette Young. The issue isn't unpaid rent, but a defective eviction notice. The landlord's lawyer admits the tenant wasn't given the full 30 days required by law. That tiny mistake is massive. It strips the court of jurisdiction. The judge makes it crystal clear: no proper notice, no case. Should landlords face harsher penalties when they don't follow the law correctly?
So you understand that?
Mm-hmm.
Okay, thank you.
thank you, Mr. Sears.
So it's 206 North Huron?
Yes.
Next case on the docket.
Court calls the case Sycamore Meadows versus Erica Jefferson.
Again, Carrie Zanon on behalf of plaintiff.
There she is. She was tucked away and back over there. Come on. Hello. All right.
So Judge, I just received the ledger as well. On this one, I'm showing $3,726, court costs of $190. So the total is $3,916. Ms. Jefferson, did you?
That's not true.
Okay. How much do you think you owe?
The judgment that you signed was for $2,400.
Oh, this is one that we've been carrying over.
Yeah, and then my rent is $0 since 2024, so 37. I don't know where that came from.
Okay, I signed that judgment that I signed back in, when did your rent go to 0?
September of 2024. They just making up numbers.
Ms. Jefferson? Oh,
All right.
I'm showing that she's $63, Your Honor.
pardon?
I'm showing that rent is $63 for Ms. Jefferson.
Okay, but even if it's 63 as opposed to 0, I think what her point is how do I get to 30, what was it?
3,700.
Understand, Judge.
The landlord's lawyer pleads with the judge. She knew. She even emailed us about it. But the judge doesn't budge. A legal line has been crossed and the case is dismissed. For the tenant, it's a temporary victory. For the landlord, it's a costly reminder that even paperwork errors can sink a case.
Well, to 39, just so that clear, how do I get to 3916 when in February there was a judgment for 2414?
Judge, I will, can we adjourn this 1 week so I can go over the numbers with my client? And then I will, hopefully have
I'll adjourn this then to March 20,
May.
2000 or 23rd,
You said
2000.
March, that's why. Sorry,
No, I was staring at the next date
I know.
after the February date.
Thank you.
May 23rd, 2025 at 3 p.m. Okay. And then let them take a look at where these numbers are coming from. But I get your point.
I will have,
Okay, thank you.
Thank
will-
you, Ms. Jimmers. Don't come in here yelling again. Like that. All right? You come back here yelling, we're gonna have a problem. You take care. You do the same. Let's call the case of, is it Shakes Corbin or Corbin Shakes?
Final overview. Across these cases, we've seen three powerful lessons. Tenants often agree to unfair deals just to avoid eviction. Landlords sometimes inflate charges or fail to manage properties properly. And even landlords lose cases when they don't follow the law to the letter. These stories highlight the fragile balance of power in housing disputes, where one mistake, one missing payment, or one misfiled notice can change lives. What about you? Do you think the courts are fair in cases like these, or do they favor one side more? Final CTA. Thanks for watching Verdict Watch. If you found this case as eye-opening as we did, hit that like button, share it with a friend, and subscribe for more real courtroom drama. Don't forget to turn on the bell so you never miss a case. And tell us in the comments, whose side are you on?
Corwin Shakes versus Bernadette Young.
Good afternoon, Your Honor. Nicola Jami, 85399 on behalf of Mr. Shakes. Apologize, my boy. I'm coming off of a cold.
Do that. Hello, your name?
Bernadette Young.
All right, this is a termination case. And where are the parties in relation to this case?
Your
have
Honor,
no idea.
Mr. Shakes is on via Zoom right now. He lives out of the state.
Yes. All right. There was no lease on this premises.
No, Your Honor. The notice was mailed to her on March 5th. We gave personal service of the complaint on April 22nd. We've given way more than enough time that's necessary under the law. We were just I'm ready to proceed with the hearing on this matter if it's necessary.
Well, except for the fact that she's a tenant at will or by sufferance. And I don't have the proof of service copy of the notice to quit, but you've indicated that notice to quit was mailed on March 5th.
That should have been in
And
the
if it-
packet.
But, okay, it's not there, but that's okay. I have a copy of the notice to quit, but not the service copy. But based upon your representation that it was mailed on the 5th, there's a problem because it indicates that she has to move by March 30th, which would mean she was not given 30 days.
Wait, hold on, Your Honor, hold on 1 second. We didn't file the complaint until April 22nd.
Oh, right.
Like
I get-
I held off on
I get
filing for
that.
that reason.
Pardon?
We held off on filing for that reason.
Well, that doesn't correct the notice. I understand you may have held off filing, but that doesn't correct the notice. The notice has to give 30 days. And the notice has to be proper for this court to have subject matter jurisdiction. The problem is by not doing that, I don't have subject matter jurisdiction over this at this point. And when I don't have subject matter jurisdiction, my only option at that point is to dismiss.
Well, wait 1 second, Your Honor. Hold on a second. Let me just clarify something. very quickly. Because that doesn't sound correct. Your Honor, can we have a brief, can we pass this very briefly?
Sure.
Thank you.
Ma'am, I'm going to pass the matter, so you can have a seat. Then I'll call you back up.
Okay.
Okay, thank you. Court recalls the case if there matter, so you can have a seat. Then I'll call you back up.
Okay.
Okay, thank you. Court recalls the case if they're ready. Corwin Shakes versus Bernadette Young.
Yes, Your Honor, Nicole Ajami, 85399, again on behalf of the plaintiff. Your Honor, I see where the issue was. My assistant had sent it over to be delivered personally on the 28th, which is the date I authorized it to go. Did not mail it until Monday the 3rd. So the notice, yes, is off by 2 days. There's 28 days. However, we did not file this complaint until April 15th. We have email communications with Ms. Young about, she knew, like she was emailing back and forth stating, I received your notice. Please give me more time. I'm looking for housing. And again, I know the notice is defective, but please ask this court to recognize that she had notice. She was communicating with us. My assistant had sent out, I'm sorry, I already said that, Your Honor. And I would just ask this court to please allow that.
Yeah, no, I hear you, counsel, and it would be an
Can we
invalid
amend it
judgment.
and can we adjourn and amend? Can we do that?
That the one thing that really cannot be corrected is the notice, because that time period has to run prior to the filing of the complaint, but the notice has to, no, hold on. But the defendant has to have that time period in that notice. Right? So otherwise, quite frankly, from a practical standpoint, you would end up with 2-week notices to people because people can't get before the court till X time in any event. But so you have to give them a 30-day notice, then file. I don't have, I understand, I think it may be a day, it may be 2 days, but that's the only way that this court can assume subject matter jurisdiction over the case is by the filing of a proper notice statutorily. So.
I understand.
All right, this being the case, the court lacks subject matter jurisdiction. This case is dismissed. Ma'am, I would assume, so that you know, I'm dismissing this case. It's without prejudice as to the issue. So my assumption is that they are going to begin these proceedings again. So they're going to be back. Okay? All right.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, folks.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.